welcome to the Data Privacy Party, the only party where the theme is data privacy every day, all the time. All right, y'all, let's get right into it. So Connecticut, not too long ago, a little more than a month, I would have to say, passed their own statewide privacy law. This was signed by Governor Ned Lamont May 10th, 2022. And this actually goes into effect July 31st of 2023. So a little bit of time until that comes in, more than a year for companies to try to get themselves in position to be compliant with this law that will essentially be Connecticut's own statewide privacy law. I know that, states like Colorado, Utah, California, and Virginia have all kind of already passed their own state legislation. Obviously, none of those apply to the state of Connecticut. However, this new one is going to obviously apply to the specific state. I know right now we have the American Data Privacy Protection Act would be kind of the first bipartisan, nationwide data privacy bill, but that one currently is still making its way up through the ranks of Congress. So that's eventually going to, we hope, pass. And so we'll get federal law. But for now, we don't have that. We have statewide. So Connecticut's the latest state to kind of push that one through. So we'll kind of go into a little bit some of the more details I want to share with you guys. So just like Colorado and Utah, Virginia as well, it only applies to companies that collect data of Connecticut residents. So specifically protects the Connecticut residents and companies that are doing business in the state of Connecticut, domiciled inside of the state of Connecticut. If y'all give me 1 second, I'll actually put this out. I got it paused. All right, we'll need to cut that out of it. So some of these companies, Aetna being one of them, that's a rather large company, United Technologies, Cigna as well. A lot of companies that have a really, a heavy presence, either headquartered or otherwise within the state of Connecticut. So some of the carve outs in the act just kind of resembles a lot of stuff that we've seen in the past, other federal laws such as Graham-Leach-Bliley, the Health Insurance Portability Accountability Act, HIPAA for short, and then the FERPA protecting the education of students in different various schools. Those are all kind of carved out. Federal law applies over state law. So if the company is meeting the requirements of that, then they also meet the requirements of the Connecticut law. The other one is the private right of action. So that is not in existence within the Connecticut law. This is going to require the state attorney to take legal action. Obviously a consumer can bring stuff to their attention, but a consumer cannot be the one to take the company to court over whatever they think the company's doing that's in violation of this act. But some of the other consumer rights they have that they can exercise, they're able to send requests for their data to the controller. This is the same kind of thing we've seen in some of the other ones in the past. They're able to submit those requests. We'll go into a little bit more later, 45-day threshold to respond. They also can send requests to delete or correct their data that the company has on them if they find that it's inaccurate or they, in fact, just want to be forgotten about. They can also obtain their data and transport this to another company, data portability. A big necessity for a lot of consumers to have access to do that, especially with the amount of data that's just out there that companies have on you and I. They can also submit requests for restrictions on how their data can be processed. So this is a little bit maybe newer than what we've seen in the past. So if a consumer, for example, does not want their data to be processed for the purposes of targeted advertising, then they can kind of pull that out and they can leave it being processed for other means. Maybe it's, analytics purposes or other other kind of things the company's doing, but not for, purposes of targeted advertising. The applicability, we've already kind of talked a little bit about that. Companies collecting data on Connecticut residents, but it would specifically apply to companies that would control or process personal data of 100,000 or more Connecticut consumers within a calendar year, or deriving more than 25% of revenue, that'd be gross revenue, so after costs and everything are taken into consideration, from the sale of personal data or controlling / processing data of 25,000 consumers or more. So controlling or process data of 100,000 consumers straight up, or deriving more than 25% of revenue from the sale of personal data or controlling or processing data of 25,000 consumers or more. Preparing for compliance, there's kind of 7 recommendations that I personally would endorse. However, keep in mind, I am not a licensed attorney. I am not qualified to give legal advice on anything. This is basically my own thoughts on what I have read through on the law. So these 7 recommendations that I would say would help you kind of right size your own data governance program, is to have a process. So the first one, have a process to allow for consumer rights to be exercised. So we've already talked about some of those and what they are. So implementing some kind of process. This can be anywhere from, an internal document that goes around, as well as off, we'll kind of get into some other ones here in a second, but just a process in place. If someone sends in a request, then Susie Q wants her data deleted, someone needs to act on that request. So this process needs to be in place, typically kind of an internal document explaining, what that is. Someone is responsible for fulfilling it and providing Susie Q with confirmation that happened. Next one is to have a privacy notice containing these 6 different items. The first being the categories of data collected, the purpose of the collection of the data. This is also at a minimum. These 6 things are needed. Detail how consumers may exercise their rights within the privacy notice, as well as explaining what data is shared with third parties and the categories of those third parties, and then the contact information of the controller. So these 6 things shouldn't be that difficult to implement. It's essentially a public-facing privacy notice on your website that is accessible to anyone visiting the website. And then these 6 things, a lot of companies that I've seen have already kind of been implementing something in, response to this, whether it be within the Connecticut or other laws that they kind of see coming through. Privacy notices needing to be a little bit more transparent around what it is that companies are doing with the data. And, this doesn't specify in granular detail about what exactly needs to be in that privacy notice beyond, references to the purposes of collection. So that can be anywhere, like I said, not a licensed attorney, my own thoughts, but anywhere, but, from we collect your data for analytical purposes to we collect your data for determining which market we should eventually break into, yada, 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 stuff, doesn't get too detailed if it doesn't have to. Just need to be in compliance with the law once it comes into effect, July 31st, 2023. The next recommendation is that a controller must respond to the request within 45 days. We talked about this very briefly earlier. When a consumer submits a request, there is a 45-day threshold for the controller to respond to said request. And this response obviously has to either fulfill what the request was asking for, or there's 2 other options. The next one is to submit a explanation as to why the request is, I guess, taking too long to fulfill, extend it by about 45 days, providing that notice to the consumer. The other option is if, in fact, the company cannot identify the individual who submitted the request reasonably, either from, if I submitted and a company can't identify who I am submitting the request, they don't have to comply with that. The same can be said if they're requesting something and the company can show that they reasonably cannot identify the individual based on the data that they have collected, they also do not have the obligation to fulfill said request. Hopefully that made sense to a lot of folks. I know it did to some, maybe not all, but essentially if the company can't identify who's making the request, or they can't identify the person based on the data they're requesting, then they don't need to fulfill the request. Another one is that they need a platform for people to submit requests on. So, essentially it's a simple website portal, or maybe a contact us form, something like that. An individual can send in a request, company receives it, and then they execute based on what the request is. Another one, this one's kind of a newer one, I guess we haven't seen as frequently, but essentially a dynamic record containing the reasons for data deletion from consumers. I think for the most part, this dynamic record, whether it's formalized or informal, can be the different email requests or notifications sent in by consumers, just appended to some kind of list that keeps track of everything that's going on. Because obviously, if a company does end up deleting data, they want to know why the data was deleted. This can also probably, more often than not, I would assume, be in the form of a ticketing system. Request comes in, support desk creates ticket, executes, closes ticket. There's your documentation. It's dynamic. You can query most of those ticketing systems for that information if it's a specific type. So I recommend, if you're going to use that, you need to make sure you implement a specific type of request to kind of keep that going, a dynamic record of the reason for deletion of consumers' data. Second to last recommendation is the technical safeguards need to be in place over consumer data. Excuse me. This would be a lot of, organizations that get an SOC report, specifically a SOC 2, would kind of fulfill this requirement. A lot of companies getting security controls over your logical access, your computer operations, change management, some of those basic IT general controls, and then additional security controls over that, because those won't account just for the processing environment. You're going to need additional safeguards around the collection, processing, storage, submitting requests, and so on of the different consumer data that's going on. Obviously access controls, encryption, retention, and so on, access management. A lot of various control types need to be in place. A lot of companies probably already have some of this stuff in place, especially those that get attestation reports, but some of them may not. And so if you don't, especially you mom and pop shops, hopefully you're using some kind of software, some kind of SaaS, software as a service product, where you don't have to implement the controls yourself. You can actually rely on what other companies are doing, because they have to meet the requirements of a lot of those areas, mainly because they do business everywhere, not just within the state of Connecticut. So highly recommend, if you haven't already, move to one of those products just for a security standpoint. If you have your own in-house developed and you have it controlled properly, more power to you. Chances are you probably have it secured a lot better than some of those larger organizations, just because of where it is. But obviously it's completely up to the business owner on what the best route is. So like I said, just recommendations here, no guidance that you can rely on from a legal standpoint. Last one is to perform a data protection assessment. This will be for all processing activities occurring after July 1st, 2023 is when this one specifically needs to go into effect. There are 4 areas, 4 risks that need to be addressed in this DPA. First one is the risks around the processing of personal data related to targeted advertising. The next one is the risks around the sales of personal data. Next is the risks around processing of sensitive data. And sensitive data kind of expands on what personal data's definition is, and I'll read it here. So sensitive data is personal data that includes racial, ethnic, religious, mental, sexual orientation, citizenship status, or physical health characteristics of an individual. This would also include biometric data, personal data of a child, and precise geolocation data. So these definitions come directly from the Act. These are not from any sort of other source. So what the definitions as stated within the bill, those are the definitions that need to be applied to the different areas: personal data, sensitive data, targeted advertising, sales of personal data, kind of what some of that stuff means, de-identified, and so on. There's a whole number of different definitions listed out in that act, and so I highly recommend kind of familiarize yourself with some of those that would pertain to your organization, so you kind of know what to expect and how to protect it. And the last risk in the data protection assessment is the processing of personal data for the sake of profiling an individual. So those are the 4 areas that, risks around sales, processing of sensitive data, processing of data for profiling, and processing of data related to targeted advertising that the data protection assessment needs to address at a minimum. Most of these assessments would address additional considerations that would kind of flow into that 6th recommendation. We were talking about the technical safeguards. A lot of what comes from that data protection assessment is going to kind of flow into the design and implementation of those technical safeguards. So, as always, I would encourage you to read the Act for yourself, get advice from an appropriate legal professional. These thoughts are my own, and coming from a fanboy such as myself, not a legal professional, I do my best to read the laws and explain them in terms that you and I, who are not legal professionals, most of us would understand, and cut out some of the legal jargon. If you want additional, advice, consulting, and whatnot from me, please visit dataprivacyparty.com, get in touch with us, comment on the videos, like, share, subscribe, whatever you prefer to do to kind of get the party going, get the word around. This has been an update from the Data Privacy Party, a party where we are providing information that allows much better decision making around one's personal data and its privacy. You are the one who should be deciding what happens to your data and not anyone else. Thanks, y'all.